Okay, so let us start, sir. Good evening, everyone. We at Rights and Responsibilities Club welcome you all to the second talk of Consumer Awareness series. Today, we have with us Honorable Dr. SM Kantikar, a member of National Consumer Disputes Redressal Commission. His long list of qualification includes MBBS, MD in Pathology, as well as he has a PhD from National Law School of India University in Bangalore. With his expertise in both medicine and law, Dr. SM Kantikar is a member of various national medical and legal associations like Family Planning Association of India, Indian National Red Cross, and several others. He is a resource person for medical negligence and consumer law at National Judicial Academy. He also served as a member of Shimoga District Consumer Forum for 4 years from 2003 to 2006, and he was an honorary professor of law and medicine at National College in the Shimoga. And now, before we begin our talk with Dr. SM Kantikar, I would like to give you a short overview of Rights and Responsibilities Club. We are a group of young people striving towards achieving socio-economic and political justice at an individual as well as societal level. We have a vision to build a community of well-educated, responsible individuals who know their rights and responsibilities. With that being said, I would request Dr. SM Kantikar to please proceed with his talk.
Good evening, friends, all the IIT students, the intellectuals. Today you have assigned me this topic and took me to your institute where I remind my medical education and my schooling. So good evening, everyone. Today we are celebrating Sankranti also. So just I called my friend in Guwahati and asked, what is Sankranti in your Assami? So she told, so I wish that is Bhogili Dehur Hobatsa Zonalu. It means Happy Sankranti to you all. And I'm happy that the organizer, the student committee, they have formed this Right and Responsibilities Club with the young people, where we need consumer education is the most vital thing in our India. Consumer movement is it is picked up now, and a lot of consumers, consumer awareness, consumer education, everything is necessary at this moment. So now I think a couple of days ago or in the last week, Dr. Ashok Patil, who was my professor also for PhD, he has covered the Consumer Protection Act. So I will not touch the Consumer Protection Act, but the silent features I want to tell you. The Consumer Protection Act, it was first enacted in our country in 1986, and after 3 decades, the new act came in 2019. It is the Consumer Protection Act 2019, and it had a lot of advantages, a lot of amendments, because after 3 decades, the lacunas, the government has tried to plug the lacunas which we were facing in the last 3 decades. Drastic changes. This new act has provided the authorities new provisions and many consumer-friendly the facilities. I will just highlight, and then we'll move to our today's subject on medical professionals' liability in this act. So this act, the new act, first thing I want to tell, the new act, it came into the force from 20th July 2020, 2 years back. And the newer changes are, the complainant the e-filing facility started, complainant can file the complaint from his place of residence. This is the most advantageous, because previously the complaint was to be filed before the concerned district forum. Means, suppose if you have purchased something in Delhi, then you have to file, or services from Delhi, then you have to file the complaint in Delhi only. Now that provision has struck off, and complainant can file the complaint at any place, preferably from his place of residence also. Then e-filing started. There is no need to file a voluminous books and other along with the complaint. You can file the complaint through e-filing. Then the most important is the jurisdiction. You are the engineering students, but I want to tell, jurisdictions means the scope of the consumer forum. You are aware, Dr. Patil might have told you, the consumer forum, it is a 3-tier system. A district forum, now it is forum is changed to commission now. District commission, state commission, and national commission. And from national commission, all the appeals will go to Honorable Supreme Court of India. So appellate authority of National Commission is Supreme Court of India. So this is a 3-tier system. From the district forum, this is known as territorial jurisdiction, means territory where the complaint can file. Now the question of territorial jurisdiction has gone. Complainant can file complaint from anywhere. Then what is the other jurisdiction? Other jurisdiction is pecuniary jurisdiction. Pecuniary means the quantum. Previously in the 1986 Act, suppose one complainant is claiming 10 lakhs, then he has to file the complaint before the district forum. If his claim is more than 10 lakhs, means more than 20 lakhs, then he has to approach the state commission. And if it is more than 1 crore, he has to go to national commission. Previously the pecuniary jurisdiction was based on the claim, the compensation claimed by the complainant. But in this new act, that has been removed, and now the jurisdiction depends on the consideration. What is consideration? Remember, consideration is the amount what you paid to purchase the goods or to avail the services. Suppose if you purchase a car, if it is 5 lakhs, if you purchase a car, if it is more than 1 crore, if you purchase a flat, if it is more than 10 crore. So this consideration, what you have paid, I have paid this much amount. So now the jurisdiction of the commission is vested upon the consideration you have paid. It means if the district forum has consideration, district forum's jurisdiction is 1 crore, for the state commission 1 crore to 10 crore, and above 10 crore, it is of the national commission. So means now all the cases will fall in the district forum, district commission, because the consideration, what amount you have paid, that will judge the forum. Now the recently government of India has taken up this call, and they have reduced the district forum's jurisdiction to 50 lakhs. So the person who pays up to 50 lakhs for the services or consideration, he has to go to approach the district forum, district commission. And above 50 crores to 2 crores, 50 lakhs to 2 crores, he has to go to state commission, and above 2 crores, he will come to national commission. So with this background and other facilities in the new act, other provisions in the new act, the CCPA, the central authority they have established, which have suo motu powers to take cognizance of misleading advertisement and other so on. So, and the further scope of mediation is there in this new act. Then e-marketing, electronic transfers, everything has taken care of. So with this brief of this new Consumer Protection Act, we'll switch over to the main subject, today's subject, that is the medical professionals under Consumer Protection Act. Now you may be aware, in 1996, 1995, the Honorable Supreme Court's judgment in VP Shanta's case, all medical services were brought under purview of Consumer Protection Act. So before 96, all the medical negligence cases were going either to civil court or in the criminal court or some professional regulatory bodies like Medical Council of India, Dental Council of India, or Ayurveda Council, and so on. This was the previous scenario. Now, in the new from 1996, our medical services are brought under Consumer Protection Act. That time, entire India, there was protest and everything that happened in the India, and many medical bodies protested. But Honorable Supreme Court held that any services which are doctor which service he provides, that will come under category of service, because there is a question of consideration. Consideration, I told you, the charges which doctor collect, that is known as consideration. The charges which the goods seller collect, that is consideration. Charges which you pay for the service, insurance services, that is consideration. So doctors are also collecting the charges, therefore they are brought under the Consumer Protection Act. Now, still now, under this act, there is this act of new act 2019. There was a misunderstanding or miscommunication or some confusion amongst our medical fraternity, that in the new act, the medical services are deleted from the act. So there was a sigh of relief to the doctors under this Consumer Protection Act. But remember, in the new act also, the services of doctors are not deleted, specifically deleted, because in the act, the services rendered by the doctor are come under purview of the new act also. So there should not be any confusion, because a lot of doctors in the medical fraternity are still under confusion, and even the district commissions in the country, they are under confusion. They are not entertaining the medical negligence cases. So remember, in both the acts, the medical services of the doctor services are held liable, or they come under purview of Consumer Protection Act. Now, just I will try to focus the slide. We will discuss, just a minute. Can you see the slides? Hello? Now we'll come to what is...
Right, sir. We can see the slides.
You can see the slides, no?
Yes, sir. Yes, sir. We can see it.
Yes. Okay. Now, let us see what is negligence. We are talking about medical negligence. What is negligence? Negligence is, in a common language or in a layman's language, it is the act of omission or act of commission. See, the words are confusing. The act of omission and act of commission. What is omission and commission? Omission means what you are supposed to do, you are not doing. This I am pointing out towards the medical profession. Suppose we are dealing with the medical negligence now. For the doctor, what he was supposed to do, he is not doing that. That is act of omission. And what is act of commission? Act of commission means what he has not to do, suppose not to do, he is committing that. See, the words are same, but meaning is there is wide difference between the both the definitions in both. So act of commission means you should not do what you are not supposed to do. That is act of commission. See now this picture, this slide shows the patient is there because everything is centered on the patient. The patient is there. The negligence, who will cause the negligence? One is either doctor or the non-medical staff or the institution also. And then you may ask me whether patient will not cause any negligence. Yes, patients are also negligent. That is known as contributory negligence. So I don't want to go into that detail, contributory negligence, because patient, suppose doctor will advise, go and do this investigation, take these medicines for so and so date, you should not take, you should not eat. Some instructions, or you come for follow-up after 8 days, patient will not come. That is his negligence. It is taken as the contributory negligence. If there is a case of negligence and patient don't follow the instructions or the guidelines that time, if the patient found to be negligent, then he will not succeed in the case of medical negligence. So the negligence will be attributed either by doctor or non-medical staff or institution. Institution here is the hospital. Hospital is also known as employer. Then see here, I have quoted some examples. Omission. What is omission? Failure to do assessment. If the patient comes in the casualty ward or in the emergency, he failed. Just casually he will check, or he will not attend to, or he may be on the phone or watching some TV or some matches or anything. So fail to assess the patient properly. Failed to give the medicines. Suppose the patient had a very high grade fever, and without medication, without a treatment of any antipyretic, now in these days, crocin or Dolo 600, you are aware, these are the common medicines. So he should give the medicine. Suppose there is a patient of chest pain. Chest pain patient comes and the doctor will just examine, he will check the BP and send him. Nothing, okay, you go. But what he omitted here, if the elderly patient coming with the chest pain, with the breathing problem, he should do ECG. So failure to do ECG, it is an act of omission, that is negligence. Then failure to refer, suppose ECG machine is not with him, or he is not able to check, or he is not qualified to do that time, he must refer the patient to other hospital. That is also taken as, if he failed to refer, that is also taken as act of omission. Then what is commission? Act of commission, you can read the wrong medication. Knowingly, suppose this patient is diabetic, but he is wrongly giving, instead of giving insulin, he is giving some different medication orally. Then the wrong treatment, malarial treatment, then placing of the investigations, wrongly placing the investigation of one patient in the other patient's file, wrong samples. These are the act of commission. Suppose patient sample labeling is wrong. If you take one sample of blood sample of one patient and labels with the other patient's name, that is the wrong act of commission. So you understood what is negligence. Because I will not go into the depth because of as you are not a medical student. So I will touch upon negligence, and I will touch what is your responsibility as a responsible student club in dealing with the consumer cases. Now, what are the ingredients of medical negligence? Okay, there was a omission, act of omission, and act of commission also. Whether every act of omission or commission implies the medical negligence? No. If the complainant want to succeed in his claim of medical negligence, the onus is on him. In the law, the onus is on the complainant to prove that the said doctor or said nurse or said medical professional or the hospital was negligent. The onus is on him to prove by these 4Ds. What are those 4Ds? There is a duty towards the patient. So the complainant has to prove there was a duty towards the patient. Then there was a deficiency in duty. Then that deficiency directly resulted into the injury and the damage. Now we will come back to previous slide also. Suppose there is an act of omission. Act of omission. If one patient goes, if he is a fracture patient, suppose one road accident and he sustained a fracture, and it is not emergency also. So if the patient, if he goes to pediatrician means the children's doctor. If he goes to pediatrician or if he goes to gynecologist, suppose I will take gynecologist or ophthalmologist. See, the patient sustained fracture of leg, and if he goes to ophthalmologist, simple example, then ophthalmologist will certainly, he will not see the patient, and he will send the patient, I will not see you, and go. So now whether it is an act of omission, one way, if it is not emergency, then it is not act of, if it is emergency, then omission. So there is no duty of the ophthalmologist to check the orthopedic patient. There was no duty. Then when there is no duty, then there is no question of treatment, there is no deficiency. And because of his deficiency, if the patient suffers anything, gangrene or anything, he is not responsible. He cannot claim, I went to that doctor, he has not treated me, and because of his non-treatment, I suffered. Because the ophthalmologist has no duty. So there is no duty of towards this patient. So in such a way, the patient has to prove. I will give another example. Suppose the one cardiac patient, severe chest pain and sweating patient, he approaches one doctor. Suppose he is not a cardiologist, the doctor is not cardiologist, but he approaches one physician or one MBBS fellow or one Ayurveda fellow. We will take any. The baseline, the family physician, he goes to clinic of family physician. Then whether there is a duty of him or not, yes, he has the family physician, he is a MBBS, though MBBS, he has duty towards the patient to check him what he is suffering, why chest pain. He will check the BP, pulse and other things. Then one thing, if he is not competent, he has to send the patient to refer to the cardiologist. But suppose if he treat the patient without knowingly, if he treat the patient, suppose he is suspecting it is a gastric cause, and that amounts to deficiency in service. Suppose that he is not a physician, he is not a family physician, he is a MD physician or physician, qualified physician. Then what is his duty? He has to take the ECG and check properly and treat the patient. Suppose if he fail to do that ECG, that is the deficiency in his duty of care. And if he failed to take the ECG and subsequent and discharge the patient or send the patient, nothing, you have just gastritis, you have no chest pain, it is not heart attack, go to the house. But in the meantime, while going to the house, in the house, he suffered severe MI. MI means myocardial infarction, heart attack. That time he will die. So now all the three ingredients are there. There was a duty of the doctor, yes. The deficiency is proved because he has not done ECG. Then third, because he has not done ECG, so there was no diagnosis of heart attack and the patient died, and the damages because of the death the family suffered financial damages and all those things will come. So the onus is on the complainant to prove his case by all the four ingredients. Unless there are all four ingredients, the courts will not fasten liability upon the respondent, means the doctor, for medical negligence. Such cases fails. Otherwise, complainant failed to prove the medical negligence. So, what are the most common errors in the medical practice? See, you can read the failed diagnosis and failed prognosis of the disease, failed to diagnose the pathology, failure in the surgery. The third is very important, inadequate and lack of communication. Many times you might have visited the doctors and they usually they won't speak more. Just they will hand over this prescription, okay, go and bring this medicine and do the things. It is the thing. This should not be there. That's why these are the errors, because why patient will go to the court? Why the complainant goes to the court? For these reasons only, lack or poor medical record. This is the most important. The most of the doctors, they lack to maintain the record. Then poor doctor-patient relationship. This is the main crux of the medical negligence. The fulcrum revolves around this doctor-patient relationship, because in the coming era, in the recent era, there is a breach in doctor-patient relationship which is causing more and more cases being filed on the doctors. Then the pressurized hospital setup, what it is? Because one doctor is working in the hospital, there is a more pressure, more patients. Suppose a gynecologist is working in a hospital, number of deliveries are coming, the load will be on one gynecologist only. The hospital setup, they will not appoint few consultants, more consultants, and they also not allow the patients to go out to other hospitals also. So this pressurized setup will cause some accidents, not accidents, will cause some negligence towards the patient care, and that time the hospital will be held liable. Then the lack of legal knowledge, yes, it is very common. We all are not perfect, or at least we are not aware of the legal liability of our existence also. So next, let us have some interesting cases. Just for your interest, I am discussing if you just, I have tried to simplify it for you students, and the spinal surgery claims. Spinal surgery, many times in this, you may be coming across the senior elders, they suffer from backache. And in common parlance, it is said, oh, disc problem and disc problem, you have disc problem. So this is a common scenario. But this is very interesting. Now the question is, who should perform the spinal surgery? It is a debatable, and now it is a questionable also. Throughout the world, it is a debatable issue whether neurosurgeon or the orthopedic surgeon should perform the spinal surgery. Remember, both the branches can perform. As on today, there is if the doctor is competent enough to handle the case, then he may be either neuro or ortho, may perform spinal surgery. But there is a rider also. The ortho surgeons, they are restricted to the bony parts of the spinal cord, spinal canal, whereas the neurosurgeons, they deal with even the orthopedic part plus the neural element. You remember this?
Just 1 second.
Okay, no problem.
All right, sir. So I think we are back. Everything is normal. You can present. You will have to present again.
Which one?
Unfortunately.
From which place? From which?
So
Same place, sir.
continue from where you last left off.
Yes.
Which? Just you locate from where? I will start from there.
Yes, sir. If you can start, just if you can just present the screen, I'll tell you.
Yes.
Where?
Sir, you can start presenting from the same option that we showed you last time. Present the box with the arrow.
Okay. Now again, no, but PowerPoint was coming or not?
Yes, sir. It was
Yes,
coming. It was
it was
coming.
coming all the while, sir. When Murtuza
No.
interrupted you, only then it
At
got
which
disconnected.
stage? At which slide we were? Just
So
move.
you turn on the slide. We'll guide you.
Where it is? 1 minute. Just wait now. What happened? PowerPoint is on desktop, or you can start from your end. Huh?
All right, sir. All right. Just 1 minute. Um, yeah. Yes. Yes, sir. You were here.
Huh? No,
Sir,
but
can you?
it's not visible for me.
Sir, you can just open Edge browser, and over there you will be able to see. Just open Microsoft Edge.
Yes.
Yes, sir. And your camera is also off, sir, so you can turn it on.
No, nothing is coming. Now, yes, now. Is it okay?
Sir, we
Hello?
cannot see your camera, sir. So we cannot see your
Now,
camera. Can you see the
now,
screen?
yes, now,
Yes, sir.
Yes. Now you are.
now is it
Yes, sir.
okay?
Yes, sir. Yes,
Yes.
sir. It's fine now, sir.
We are on which slide? This slide? We are on
Yes,
this
sir. Yes,
slide?
sir. Yes, sir.
Shall I continue?
Yes,
Yes,
sir. You
sir.
can continue. Sir, just
You
let
can
me know if
continue.
you want to change the slide. I will change it from here.
You will change the slide? Okay.
Yes, sir.
So
Just
I
let
will
me
not.
know.
So
Just
this
wait
final
there and I will change it.
the okay. Sorry, we are yes. Okay, this spinal surgery claims there is a conflict between neurosurgeon and the spinal surgeon. Remember, and most of the time, everyone, both the surgeons claim we are competent, but better the team of both shall perform the operation that will solve many problems. In one of the cases which we dealt here, the it was a case of kyphoscoliosis, means the congenital deformity of the spine of the baby. The child was around 8 or 9 years old, and the orthopedic surgeon, the spinal surgeon, who was more experienced in the spinal surgery, he operated the child, but accidentally that the screw which was left, that was loosened, and penetrating in the spinal canal. Immediately that was noticed from the CT scan, and then neurosurgeon was called and the screw was removed. But there was no injury to the spinal cord, and we have not hold the doctor or the hospital for the negligence. Next slide, please. Next. Then next case is the one, the failure to investigate. Failure to investigate, this is the very typical case. The neurosurgeon was in hurry. He has to go to Dubai. And the patient was operated for meningioma, means tumor in the brain. Meninges, the covering of the brain are known as meninges. There is a tumor of the outer covering. It is a meningioma. And he operated and went off. But thereafter, the bleeding started in the brain hemorrhage in the brain, and patient finally succumbed. Then the case was investigated. It was noted that pre-operatively they have not investigated for the bleeding disorder. The hospital has not investigated the patient for bleeding disorder. Very simple investigations like bleeding time, clotting time, or prothrombin time. Such bleeding disorder investigations they are not performed, and the patient was operated because they just asked the patient whether you have any history of bleeding tendency. Because when you, for a common, if you go to some dentist, dental surgeon for the tooth extraction, he will just ask whether you are diabetic, whether there is any bleeding tendency, like that. In this brain surgery is very, very typical, very complicated surgery. It is the duty of the doctor to investigate the bleeding diathesis. Bleeding tendencies should be ruled out before putting the knife. But the hospital failed, and the patient later on suffered bleeding and died. So we held the hospital liable. Next slide. Next, please. Held it was not a reasonable and standard of care from the high-tech super specialty hospital. The doctor failed in their duty of care for not advising relevant investigations. Yes, you can read that facet term, the Q facet per alum facet per se. What it means? Though doctor is acted there, it was the wrong of the doctor, but the vicarious liability was on the hospital. Vicarious liability means the master is responsible for the act of servant. It is vicarious liability. For the wrong acts of the doctor, the hospital will be also held liable. Next. Yes. This is a very typical case. You might have read in the newspaper also. And Prashant Dhanka, he was a best brilliant engineering student. He sustained he suffered by medical negligence in the year 1990. Recently, he expired in 2011. Recently, June 2011, he expired. This was the case when he was a 20 years boy. The chest tumor was noted, and in the NIMS is the Nizam Institute of Medical Science, Hyderabad. They performed the surgery. The surgeon performed the surgery in the chest, the tumor, but the tumor was extending into the spinal canal. That time, neurosurgeon, it was the case of neurosurgeon, but the surgeon operated. It was a diagnostic operative. It was not therapeutic. It was a diagnostic surgery, but they have resected the tumor. The tumor extension was in the spinal cord. Therefore, this Prashant suffered paralysis below waist. He suffered paralysis, and he suffered medical negligence. Throughout his life, he became crippled. And after 20 years, he died in 2011. the Honorable Supreme Court decided the case in 2009 and awarded 1 crore that time. It was the highest compensation during that era. Next, please. Next. Yes. See the history, tumor of chest, and what I told, it is there. Next. So few words about the consent. Now time is trickling. Because consent is very important in the medical practice. Now you can read consent means it should be informed consent. The doctor should inform the benefits of treatment, risk, alternatives, and no treatment. And the documentation is very important. The brand is. So what message I want to give, as you are engineering students, you are no way concerned with the medicine. But as an engineering student, there are number of branches, number of instruments which are developed through the engineering brains. The man-machine combination is there. Hospital uses many instruments, many monitors. So if the fault in the monitor, that will be who is responsible. The maintenance is very important. So the high-ended equipments, which if the faulty equipments, you might have read in the newspaper the Johnson and Johnson case. Johnson and Johnson's, it has withdrawn the hip prosthesis. The hip prosthesis, it was releasing cobalt, and a lot of patients, they suffered cobalt toxicity. So they have withdrawn that prosthesis, that implant. And they have in the billions of dollars were awarded throughout the world. They have awarded, and in India the cases are going on. So as an engineering students, as a prudent consumers, as a prudent consumer activist, you have many responsibilities, because everyone will go to the hospital. Now your responsibility is to follow the instructions from the doctors, give correct history to the doctors. If you means you or your relatives, anyone going, check and preserve all the prescriptions, all the details of the hospital details which hospital provide, because sometimes you may need, if you suspect any negligence from the doctor, because it is onus is on the complainant to prove the case, not on the doctor. In few cases, the hospital has to prove the cases. There are certain other cases. I will not go into that detail. Then moreover, the consent. Suppose you are consenting for the operation. Who will give the consent? First is the patient. Patient shall give the consent. Suppose patient is not in a position to give the consent. Patient is comatose or under influence of drug or alcohol or anything. Patient is illiterate. Patient is a child. Then who will give the consent? The nearest responsible person, preferably the relative in case of child, parents, then wife, husband, the closest relative will give the consent. Now the consent is very important. If Samira Kohli, I wrote that case, Samira Kohli's case, that is very landmark judgment of Honorable Supreme. Consent was given for diagnostic test, but the doctor performed hysterectomy. So the court held that the consent was for only one specific area, one specific procedure. You have extended. So it is not amounts to an informed consent, so the hospital was liable. So remember, consent, you will come across such situation that you have to give the consent. Consent, there are number of types of consent. High risk consent is there, implied consent, applied consent. Then there are a lot of consent. But remember, for the surgery, informed consent is necessary. Only signature on dotted line will not be a consent. You have every right to ask the hospital, explain me what you are doing, I will not sign the consent form. Just fill up the form and you should be vigilant. Then the next slide, please. remember the medical record. Next, yes, yes, the medical record. Yes, just medical record. Medical record. Remember, you need the medical record to prove your case. The doctors need the medical record to prove their case. So medical record is a vital and very important aspect in the medical malpractice or medical negligence cases. If the records are good, it is a good defense for the doctor. If the records are poor defense to the doctor and best remedy for the patient or the complainant. And if there is no medical record, then the court will straightway fasten the liability on the hospital or the doctor. Next, please. Next. Then certain issues with respect to medical negligence, which connects with the engineering also, the telemedicine. Now you are observing in the COVID pandemic, lot of telemedicine is going on. If anything goes wrong, then who is responsible? Whether the doctor or who is online through telemedicine. So this is very gray area. Then the cross-pathy. Cross-pathy means the other specialty doctors, they are treating one patient. Suppose allopathic medicines to be given by allopathists, and whether the Ayurveda or homeopath can give the medicine, because now Ayush government has permitted, but they can give, there is a notification and they can give the medicine unless they know the dosage and they are well versed with that. The notification does not give the immunity or immunity to the doctors of other specialty to do any wrong under such circumstances. Then the misleading advertisement, yes, it is very prominent area, because I will cure the AIDS. Many times you have seen the advertisement. AIDS will be cured, diabetes will be cured by a few medicines, your color will be changed, you apply this cream. These are misleading advertisements. So these are also categorized under medical negligence. Then medical ethics, it is very vast subject. Then the defensive practices, because of medical negligence cases, more cases are being filed on the doctors. The doctors are trying defensive practice, unnecessary investigation. So the burden is on the patient population. Therefore, we need best doctor-patient relationship, trust on the doctor and trust on the patient also, vice versa. Then the role of expert evidence, it will come when the cases are going on. It is not at this stage we will discuss. So thank you very much, and I will be happy to answer your all the queries. I'm sure you might have many queries. This is our commission, National Commission, Delhi. So be a vigilant consumer. Thank you. Let us have a discussion. Any questions?
Yes, thank you so much, sir. We actually have a few questions from the audience.
Yes.
Would you like to take them, or should I read them out to you?
No, you can read, because to screen from the chat box is difficult. Yes.
Okay, sure. So the first question,
Yes.
Saurya Ravi is asking, in an alleged case of medical negligence, what proof should the consumer have or provide for their case to get accepted?
What proof? I told if you want to succeed in that case of medical negligence, he has to prove all 4D. Now, first thing, he need medical record. Suppose if you want to allege, I had gone to this doctor, he has prescribed me this and this medicine, and because of this medicine, I suffered this complication. Suppose this is the simple allegation. Now, in this case, you have to prove the prescription should be with you. That is the medical record. Whether that prescription, the tablet is correct or not, you have to prove that the tablet was correct or not. whether the dosage was correct or not. So what he need here is first is medical record, proper and suppose patient is hospitalized and he want to file, he is alleging some medical negligence happened in the hospital. Now he will need the medical record from the hospital. So he can approach the hospital and request the authority, because hospital will give the discharge summary, and he has every right to approach the hospital and get the medical record, entire medical record, with the payment of certain fees, or it depends on the hospital policy. They will issue the medical record. Yes.
Okay, I hope Sorry Ravi has got the answer. Next question is by Akshara. She is asking, misleading ads about weight loss products, hair gain products, etc. What can we do to increase the consumer awareness about all these products?
For the misleading advertisement, the consumer can approach the any nearest consumer forum, file a complaint, and they may issue the direction to the company, the advertiser, about the stop this advertisement, and action will be taken. Secondly, now the central authority has been established in the new act, CCPA, the Consumer Central Authority in New Delhi. So it is in the larger interest, the consumer can write the CCPA and file the complaint before the CCPA, and CCPA will suo moto investigate. CCPA has the power to investigate and stop the advertisement also. And the punishment, I think there is a punishment for the misleading advertising around 5 lakhs or so. In the new act, the CCPA can impose the fine and punishment also. Yes.
Okay, thank you so much, sir. Next question is by Adhiraj. He is asking, in COVID period, there were excessive sale of false goods and unprescribed medicines were used in the market. How do we address this issue?
No, I could not get you. What in the COVID period?
There were excessive sale of false goods and unprescribed medicines in the market. So he's asking, how do we address this issue of false medicines and unprescribed goods which
No,
were being
see,
sold?
there are two hurdles in this COVID, because under the disaster act, which I just what I feel in the under disaster management act, there are some exemptions for these wrongs. Secondly, selling the medicines with disproportionate price and other, that will go to the drug control department. The complainant can approach the drug control department or the government only to stop such malpractices, because this will come under consumer protection, excessive charges and other, but whether it will stand before the consumer protection. It is because COVID is a pandemic, and throughout India it was you have to address the issue throughout India. One remedy, he may approach the Consumer Commission, this CCPA, Central Consumer Protection Authority, and file the complaint, and they will take the issue. Or approach the High Court under writ. These malpractices are going, and this should be curtailed. This is the best. Yes.
Okay. The next question would be, last year government announced Ayushman Bharat Digital Mission. How would this be beneficial, and what are some of its possible problems in this specialty, specifically in terms of data safety?
No, Ayushman Bharat is, I think it is good. There is no doubt. Ayushman Bharat, because the aim of government is to provide all facilities to the baseline consumers or baseline patient also. And under that, yes, but it is in the primitive stage. We need proper training to the doctors and all the other people in this Ayushman Bharat, because Still it is gray area because who will charge, because many corporate hospitals, many big institutions, whether they accept or not, that is not, that's still under developing stage. But Ayushman Bharat is really good. It will address number of diseases. They have enlisted the diseases also, the operations also. This facility, if it works out, it will be very good for everyone's health.
Okay. The next question in the chat box is, what will be the emerging trends and challenges in consumer protection in the aftermath of the pandemic?
For the pandemic?
After the pandemic is over and we switch back to normal. So
No,
he's
see,
asking what
in the pandemic, now we are getting the cases of alleged medical negligence for the COVID treatment also. Means if there is any wrong treatment or any wrong failure of duty of care towards the COVID patient or non-COVID patients, they are coming, and the complaints of medical negligence being filed on such issues also. So they are not exempted, because previously that was the notion. Because of the Disaster Management Act, we are protected. No, if the wrong is done despite during the COVID treatment also, that will be construed as a medical negligence only. And post-COVID also, post-COVID complications. Suppose post-COVID, the COVID, we have no clear picture which complications COVID will bring later age. Suppose I suffered COVID today and I have given remdesivir. Now the concept of remdesivir, remdesivir, they have given 5 doses of remdesivir. And whether the utility of remdesivir was correct or not. Now whether it is a negligence or not, this is the question. Suppose by the remdesivir somebody develops some complications in future. Whether that hospital or that doctor is to be held liable for that wrong. See, the thing is, because this injection of remdesivir was approved from the WHO previously, then it has withdrawn. Now, when there is an approval from the authority and they are doing, it will not be construed as a negligence. But later on, when they have stopped the remdesivir, there is no use of remdesivir, you should not use. At this stage, suppose now they are using, now this is the second or third wave, and now they start using. That time, definitely, when the banned drug, you are using the banned drug, that will attract negligence in the present scenario. So the complications of COVID, how you treat the complications, whether it was really COVID or non-COVID, if it is not COVID also, you are not treating the patient, then he is held liable. Suppose the COVID patient, they are not conducting the operations also. You are COVID positive, operations are not doing. But the government has not banned. If you fail to do the operation, if the patient is COVID positive, you have to do the operation if it is necessary, emergency operation. If it is elective, you can postpone it. But if it is any emergency, you can't shirk away. Because you are COVID, I will not operate. The patient will die. Then who is responsible? That time liability of the hospital will come during pandemic also. Yes.
Okay. We have another question in the chat box. The question is, major brands like Pathology and other homeopathy brands, they claim that they have made COVID medicine, and people gathered here to the medical stores to get it because it was publicized in mainstream media news channels as well. So why did the government did not take serious effort to stop this?
No, the CCPA, this is very difficult question, and I think I will prefer to avoid it. Yes. It is a pertinent issue. The government should take call, but I am not expert to comment on those things. Okay.
Sure, sir. Sure.
Okay.
Sir, I think those are all the questions.
Yes.
If you have any remarks to give to the audience, otherwise we can end the session.
No remarks to audience. Only I will tell you all, one or other day you will visit the hospital or a doctor, or you need medical attention or vaccine or anything, any simple. But I wish you should be away from the medicine, medical. I being a doctor, I will advise take good food, be healthy, and avoid the hospital, medical treatment. Suppose if the circumstance arises, at that time, what I feel, the young generation should keep the track of their health record. What I suffered today, make a mention, keep a diary, or keep a, now the electronic era, you can keep all the things in the this electronic mode, because after 20 years you will not remember that yes, I suffered by this, because that will help the clinician after a few years to correlate, because many instances which we saw, for example, rabies, you know, rabies, dog
Yes,
bite.
sir.
Yes.
The rabies virus is very slowly progressing. Maybe 1 or 2 millimeter per year it will progress. Suppose virus is there, and it will reach the brain in the negro bodies and the brain matter. It will reach, and that time it will present. Suppose in the childhood or in your adulthood, sometimes your own pet dog also some bite was there. You will forget it is my house dog and other thing. But this should be noted. This such history should be noted. Yes, during my school age, my pet dog or pet cat, I had a bite, and there was a dressing made during my at the age of 15 years, because this virus will present at the age of 40 years or 50 years. The doctor has to get the clue, no? But if you say no, what doctor will ask whether you have any dog bite or any history of any bite. You say no, I don't have any bite for the last 2 3 years. This is, but to correlate, to arrive with the proper diagnosis and treatment, you need to maintain the record. Health record is essential, as a medical record is essential for your better health. So I wish you practice. Every year you practice what I suffered, simple fever, this is the good way. So I think I have clarified with my little knowledge, and I wish all of you happy Sankranti, happy New Year, and best future.
Thank
And
you, sir.
Guwahati is very nice place. It is wonderful place, and you are placed in good place. So I wish you every success and best life. Thank you.
Thank you
Thank
so
you.
much, sir.
Thank you.
Thank you. I'm ending the session right now. Thank you.
Oh yes, thank you.